Good evening, everyone. Good evening, attorney. I'm Shane Sarsalejo, and I will be reporting on a neutral service and the subtopics under that penalty for a neutral service and the termination of neutrality. And then my second topic is the introduction of international environmental laws. Under that is a declaration of the United Nations Conference on the Human Environment. So in times of armed conflict, the law of neutrality governs the relationship between the belligerent states and the neutral states. A central duty of a neutral state is impartiality. A neutral service. So what is a neutral service? It is defined, is an act by a neutral vessel or person that assists a belligerent in a way significant enough to make them a hostile or hostile entity, thereby losing their neutral status. So it is more of a severe offense than carrying a contraband, because it is not merely a commercial transaction but an active integration into the belligerent's war effort. So, what are the key elements? Number one is the carriage of any enemy person. So, this is knowingly transporting members of the enemy's armed forces. Second is the transmission of intelligence information in the interest of the enemy. So this is example for this one is the transmitting intelligence like via radio or signaling to a belligerent, especially if the voyage is specially undertaken for this purpose. And lastly, providing aid such as refueling, repair of an enemy vessel, other services directly in aid of or under orders or control of the belligerent. So the crucial distinction between carrying a contraband like weapons is seen as a private commercial venture, though the goods are liable to seizure. Um, a neutral service, however, is seen as the vessel itself becoming um, a hostile participant and an auxiliary to the enemy's military defense. Article 46, 1909. Article 46 of the 1909 Declaration of London states that a neutral vessel will be condemned and in a general way receive the same treatment as would be applicable to her if she were an enemy merchant vessel. So a neutral vessel will be condemned if number one, if she takes a direct part in the hostilities. Number two, if she is under the orders or control of an agent placed on board by the enemy government. Number three, if she is in the exclusive employment of the enemy government. And then number four, if she is exclusively engaged at the time either in the transport of enemy troops or in the transmission of intelligence in the interest of the enemy. Number Next is activities that do not constitute a neutral service. This includes continuing normal commercial relations. So, a neutral state it is generally entitled to continue its existing commercial relations and trade with belligerent states. This is known as the courant normal. So, this includes allowing private persons or corporations within the neutral state to export non-military goods and raw materials, even if those materials may indirectly benefit a belligerent's economy. Next is the activity of inspecting cargo and issuing certificates. And this is also called as the Navy certs. So the fact that a neutral merchant vessel has submitted to the inspection and certification, the Navy cert, the inspection and certification mechanism of one belligerent party to show it is not carrying contraband is not an act of a neutral service against the other belligerent. Next is humanitarian assistance. So, providing impartial humanitarian aid to victims of the conflict, whether military or civilian, does not violate neutrality. The assistance must be based solely on need and not intended to provide a military advantage. Next is private citizens enlisting in a belligerent's armed forces. So this is with conditions. A neutral state is not actually required to prevent its nationals from voluntarily entering the military service of a belligerent on their own initiative and responsibility. However, the neutral state must not officially encourage or facilitate this, for example, by allowing recruitment drives on its territory. And then there is also the use of general communications infrastructure, allowing parties to a conflict to use pre-existing generally available non-military telecommunication installations like the public internet or commercial satellite communications. This does not constitute a neutral service. And then defending neutrality. So when a neutral state is using force to repel attempts to violate its neutrality or sovereign territory. So, for example, forcing entry of belligerent troops or ships to disarm or intern them cannot be regarded also as a hostile act. And then lastly, the transport of certain personnel. So historically, there were exceptions for the removal of certain persons from neutral vessels, such as escaped prisoners of war who arrive on neutral territory and are left at le- uh, um, at liberty. So, in its entirety, a neutral service is in essence the an action does not constitute a neutral service if it does not amount to direct state assistance to a belligerent's war effort, or if it is part of standard um, impartial commercial or humanitarian activity that does not give one belligerent a significant military advantage over another. So under the Hague Convention of 1907, uh, ordinary postal correspondence is exempt from unnecessary interference, whatever its official or private character may be, unless proceeding to or from a blockaded port. And also, it also provides that a neutral cannot avail himself of his neutrality if if he commits hostile acts against a belligerent, and if he commits acts in favor of a belligerent, particularly if he voluntarily enlists in the ranks of the armed forces of one of the other parties. So, what is the penalty of a neutral service? Um, okay, the penalty of a neutral service. So, under Article 45 of the 1909 Declaration of London, it penalized in the same manner as the carriage of contraband. So what will happen with the neutral state? It will lose its neutrality. So it will become a hostile state. And then the vessel will be subject to the vessel who was who that may have carried the contrabands or the military personnel is subject to capture or condemnation. And then the neutral agent, this neutral agent must identify himself with as a belligerent. So what will happen to the neutral agent? He may be treated as a prisoner of war, and the means by which he acts is liable to seizure, confiscation, or other treatment. So the means here means that the means by which he acts is liable to seizure, or they will be seized, confiscated. These means are all items issued for military use. So they become the property of the capturing state. They are permanently confiscated and do not need to be returned. Next is the termination of neutrality. So a state's legal status of neutrality, whether declared unilaterally or established by treaty, is not necessarily permanent. So it can be terminated under several specific circumstances. So it can be terminated under several specific circumstances, like joining the conflict. So the most obvious way is when the neutral state abandons its impartiality and joins the war, either by declaring war on one of the belligerents or by committing acts of war. Second is becoming a co-belligerent. So in this circumstance, a neutral state may lose its neutral status if it systematically or significantly violates its duties of neutrality. So, for example, if it provides substantial, non-impartial military and financial aid to one side, the aggrieved belligerent may cease to regard it as neutral and treat that state as a co-belligerent or a party to the conflict. Next is the circumstance of the end of the armed conflict. So if there is no conflict or war anymore, the status of the neutrality exists only in relation to a specific armed conflict. So if it ceases to, or if there is an end to that conflict, then um, for example, through a peace treaty or a armistice, the law of the war ceases to apply. So and with it, the concept of neutrality ends in that way. And then next is the UN Security Council action. So in this circumstance, um, under chapter under the UN Charter, the Security Council can authorize collective action, including military force, to maintain or restore international peace. So calls on member states to take measures against an aggressor. A state's obligation to the UN overrides its traditional duties of neutrality. And then lastly, being attacked, the circumstance of being attacked. So if a neutral state is attacked by a belligerent, it acquires the right of self-defense or bound its neutral duties, as it has become a party to the conflict. The neutrality of the state ceases upon the conclusion of peace, and the neutral state will then be governed by the peace treaties and or laws of peace. Next. Okay, so we'll go now to the international environmental law. So under Article 2, Section 18 of the 1987 Constitution, it provides that the state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. So the very famous landmark case of Oposa versus Factoran Jr. GR number 101083, decided on July 30, 1993. So in this case, the Supreme Court held that the right to a balanced and health, healthful ecology, although not listed in the Bill of Rights, is fundamentally important, perhaps even more so than civil and political rights, because it concerns human self-preservation and self-perpetuation. This right is considered inherent to humanity. So it is existing even before constitutions. Its explicit inclusion in the Constitution as a state policy um, shows how important or its critical importance, and imposes a duty on the state to protect the environment and health, preventing ecological destruction for present and future generations. Okay, so this is the infographic of the case of Oposa versus Factoran. Um, the paramount or the very distinguished ruling of the Supreme Court was that the intergenerational responsibility, the intergenerational responsibility. So this was introduced in this case. So this involves the right to a balanced and healthful ecology, and that every generation has a responsibility to the next generation to preserve the rhythm and harmony for the full enjoyment of a balanced and healthful ecology. The minors or the young factorants' assertion of their right to a sound environment constitutes at the same time the performance of their obligation to ensure the protection of that right for the generations to come. Okay, so now let's go to international. This is the introduction to the international environmental law. So, international environmental law is also called as an international ecological law. So, the meaning of this is a field. This is the field of international law, regulating the behavior of states and international organizations with respect to the environment. The core domains for international regulation includes climate change and atmosphere protection. So, this domain focuses on regulating the emission of greenhouse gases and substances that deplete the ozone layer. Next is the biodiversity and wildlife conservation. This area involves protecting ecosystems, species, and genetic resources to prevent extinction and habitat loss. Next is protection of the marine environment. This one governs the preservation of oceans and fisheries, aiming to prevent pollution and manage marine resources sustainably. Next is the regulation of chemicals and hazardous waste. This domain, it focuses on minimizing the generation and controlling the transboundary movement and disposal of toxic and hazardous substances. Next is water resources management. This includes regulating the quality and use of transboundary water resources like rivers and lakes to ensure clean water supply and prevent pollution. Lastly, it regulates sustainable development and environmental impact impact assessment. Uh, these are It integrates environmental protection with economic and social needs across all sectors. It often requires environmental impact assessments for major projects. So the main international treaties concerning environment, so these were the treaties that were created. First is the 1972 UN Convention on the Human Environment, or the Stockholm Declaration. Second is the 1992 United Nations Conference on Environment and Development, or UNCED. This one produced the Rio Declaration. Next is the 1997 Kyoto Protocol, and then the 2002 World Earth Summit. The United Nations Conference on the Human Environment, this is also known as the Stockholm Declaration. So this this was declared in Stockholm, Sweden on June 5 to 16, 1972. The significance of this declaration is to explicitly recognize the right of everyone to a healthy environment and the importance of protecting all species and their habitat. And then the other significance is the need for a common outlook and for common principles to inspire and guide the people of the world in the preservation and enhancement of the human environment. So the Stockholm Declaration, this contains 26 principles, 109 recommendations, and then it also created UNEP. This is an environmental agency, and then it added the adoption of the Stockholm Action Program. Note here that there was no legally binding outcomes resulting from the Stockholm Conference. So the outcomes of the Stockholm Declaration, they were not legally binding because the Stockholm Declaration was intended to be a soft law instrument. So it means that the set of 26 principles and proclamations to inspire and guide the peoples of the world. So the very purpose of it is the aim was to establish a common outlook and a political consensus, um, staking out the first global agreement that environment protection was a major issue. And then its intention was it may lay the foundation, um, and it will be seen as a prerequisite, a necessary first step to establish the principles that could one day become the basis for binding treaties. And the Stockholm Conference had to be non-binding in order to succeed. Its purpose was to start the global conversation and build political will necessary for the legally binding actions that would follow in the decades to come. And that's it. That's the end of my report. And thank you and good evening.